Hello dear friends and followers, welcome to Vidhi Vyakyan. In this video, we are going to understand about one of the landmark judgment of Supreme Court, that is M.C. Mehta versus Union of India 1987. This case was relating to the leakage of oleum gas that caused severe health issues to the people who are residing near the region of the industry, and Supreme Court in this case has laid down one of the important principle, that is absolute liability, which made the industries accountable without their fault in case of any accident. So let's understand this case in brief. Brief background of the case. Shriram Food and Fertilizer Industry had multiple units engaged with manufacture of sodium hydroxide, chlorine, superphosphate, oleum, etc. All units are located in densely populated areas like Shastri Nagar, Ashok Vihar, Trinagar, near the outskirts of Delhi, that covered approximately 76 acres of land. On 6th December 1985, the District Magistrate of Delhi ordered Shriram Industry to cease the occupation of manufacturing hazardous and lethal chemicals, that includes chemicals like oleum, phosphate, chlorine, etc. under Section 131 Subclause 1 of CRPC, seeking to withdraw the chemicals. When this order was challenged before the court and it was pending, M.C. Mehta approached Supreme Court to seek compensatory relief of the damages incurred through filing of a PIL. Now let's focus on the facts of the case. A writ petition was filed by M.C. Mehta, a social activist lawyer, seeking to closure of Shriram Industry, which is used to release hazardous chemicals and gases, located in Kirtinagar, Delhi. On 4th to 6th of December 1985, there was a leakage of oleum gas from Shriram Industry when the writ petition was still pending before the court. This incident happened 1 year later of Bhopal gas tragedy. Due to the leakage of oleum gas, very large number of people suffered from health issues and respiratory disorders. Even an advocate died due to this incident. M.C. Mehta filed a writ petition before the Supreme Court under Article 32 of Indian Constitution to give effect to Article 21 of Constitution, seeking to order for the closure of hazardous industry and to grant compensatory remedy to the people who are affected due to this incident. Now let's focus on the issues involved in this case. The first issue was about what is the scope and ambit of the jurisdiction of Supreme Court under Article 32 of the Constitution. Whether Article 21 is available against Shriram Industry, which is owned by a Delhi cloth mill, a public company, or in other words, whether Shriram Fertilizer Company is a state under Article 12 of the Constitution. The third issue was about what is the measure of liability of an enterprise which is engaged in release of hazardous or dangerous chemicals. The fourth issue was, does the rule in Reliance versus Fletcher could be applied in this case? Now let's focus on the arguments advanced by both the parties in this case. The petitioner argued that the nature of the activity of the industry was harmful and dangerous to the lives of the people and health of the community at large. Hence, the industry must be made absolutely liable. And it was also argued that the operation of such industry near the areas of city violates Article 21 of the Constitution, which impliedly includes right to life, right to health, right to clean environment, and Shriram Industry comes within the ambit of Article 12 of the Indian Constitution. And the petitioner claimed the compensation to be paid to all victims as industry failed to take safety measures and was absolutely liable for such incident. While the defendant argued on the behalf of the industry that Shriram Industry was not a state under Article 12 of the Constitution, Hence, it could not be made liable under Article 21 of Indian Constitution. On 12th of December 1986, five-judge bench of Supreme Court headed by Chief Justice Bhagwati delivered the judgment in the favor of the petitioner. While Chief Justice Bhagwati showed his deep concern for the safety of Delhi people from leakage of hazardous substances, he was of the opinion that the policy of total ban on hazardous industry cannot be adopted as it helps to improve quality of life, creates employment, and useful for accelerating economic growth. Focusing on the first issue, the Supreme Court observed that the power under Article 32 of Indian Constitution is not only confined to preventive measures but also it extends to providing remedial measures when the rights are already violated. The court also stated that it entertains the compensation claim under Article 32 of Constitution only in exceptional cases. On the question of whether industry is a state under Article 12, the court relied upon previous decisions like R.D. Shetty's case, Ajay Hasia versus Khalid Mujib and others. Thus, the court included industry as a state and granted relief under Article 21 of the Constitution. In deciding the liability of hazardous industries, prior to this case, the rule laid down in Ryland versus Fletcher was applied, which says that if a person who brings onto his land and collects and keeps there anything likely to harm, when such thing escapes and thus causes damage to another, then liability would be strict. But in many cases, industries used to escape from this liability, taking defenses like act of God or act of stranger, etc. So the Supreme Court introduced a new rule called absolute or no fault liability, which states that an industry engaged in hazardous industry which possesses a potential danger to health and safety of persons working there, and even if there is no fault on the part of industrial management, the industry could be held as absolutely liable. Anything danger happens, then such industry cannot escape from the liability to pay compensation and is absolutely held liable for such incident. On the question of determining the compensation, the court applied a simple rule that larger and more phosphorus the industry, greater will be the amount of compensation payable by it. Thus directed the industry to pay compensation to the victims and laid down certain guidelines for the working of hazardous industries.